So this news article concerns an employer's failure to consult in a redundancy situation, and that can lead to fines of up to 90 days' pay for each affected employee. Now the facts in this case concern a company called the Southport Theatre Convention Centre, the STCC, which is in Merseyside, and it employed 23 staff. It announced its decision to close its doors on social media channels in May 2020, a couple of months after the pandemic began in the UK. And when it made that announcement, it also said that it would be making all of its staff redundant at the same time. So what is the duty to consult in redundancy situations like this? Well, the core thing is to allow sufficient time to engage meaningfully with employees in consultation. And meaningful consultation in a redundancy scenario means looking with the employees at ways to avoid the redundancies happening at all, or if they can't be avoided, to mitigate the impact on the employees who are ultimately made redundant. Now you may ask, what is sufficient time for a consultation to take place? And the answer is, it's as long as it needs to be. But it needs to be sufficient to allow discussions, for employees to make suggestions and counter proposals, and we suggest as a rule of thumb at least 2 individual one-to-one meetings. Now when we're advising clients at my HR department and they ask us how much time should I allow for a redundancy consultation for a non-collective redundancy, and that means less than 20 people, we tend to say, look, it's not going to take less than a couple of weeks at least. But if it's more than 20 people, then the collective consultation rules kick in, and these are set by statutory instrument. So for 20 or more employees who are going to be made redundant in a 90-day period, there is a minimum consultation time of 30 days. And that means that the employer has to consult with the affected employees or their representatives for at least 30 days before they make or they issue any notices of redundancy. Now if that goes up to more than 100 employees who might be dismissed because of the redundancy exercise, then that collective consultation period, the minimum period, goes up to 45 days. And there are additional obligations on employers too when it comes to collective consultation. First of all, they have to allow employees to elect representatives to act on their behalf. They have to train those representatives before the consultation can even begin. So going back to the Southport Theatre Convention Centre, which very sadly had to close in May 2020, what did they actually do wrong? And could they have relied on something which we call the exceptional circumstances defence? The exceptional circumstances defence is the only way that an employer might be able to get around the obligation to collectively consult with its employees. And in order to get away with that, the employer would need to show that consultation wasn't reasonably possible with the employees that were going to be made redundant. So for example, early in the pandemic, if a business had been destroyed very quickly by the requirement to close because of COVID and it couldn't be foreseen, then the employer might have been able to get away with the exceptional circumstances defence. Now, the exceptional circumstances defence wasn't open to the employer under these circumstances, and that's because the trade union who represented the employees was able to show the tribunal that the employer had actually been involved in discussions with the local authority about potential closure for a good couple of months before the announcements were actually made in May. And the trade union, quite rightly in our opinion, said, well look, if they were able to talk to the employer for a couple of months, why couldn't they also consult with the employees? The award in a case of failure to consult collectively in a redundancy situation is up to a maximum of 90 days pay per employee. The employee obviously being dismissed for reasons of redundancy. And in this case, the tribunal awarded the full award. There was clearly, said the tribunal, an opportunity for the employer to consult, but they didn't do it. Now, I would also suspect that the employer's decision to issue notification of redundancy via social media feed probably didn't endear them to the tribunal either. Whether that's a factor in why they decided to award the full 90 days, I don't know. But what is the moral for other employers from this particular example? Well, I think the moral, quite obviously, is that if you think you need to make redundancies, you should start consulting as soon as it's possible and not wait until it's a foregone conclusion. Collective consultation is not actually that difficult. We have videos as a start point on consultations, individual consultations I think they are, but the principles are much the same. And that's as good a starting point as any for an employer. But collective consultation is very well understood. It's a simple mechanical process, or relatively simple mechanical process. And of course, if you need help with it and you have a consultation or a collective consultation to run, we would be happy to provide you with support.